So this lady's benefit is less than $500 per month.
Wow.
But I took on this case because it was a BS denial, and we can't let that happen, right? So we didn't let that happen. Now we have her back on claim now. But again, the appeal almost wrote itself because we did so much background in this case to make sure that Guardian had no alternative but to reinstate this claim.
Hi, I'm attorney Greg Dell, joined by attorney Alexander Palomara, and we're going to discuss one of Alex's resolved cases against Guardian. Alex, we've handled a lot of cases against Guardian. They're one of the largest group disability insurance companies in the country. And recently, they've been one of the most difficult companies in the country to deal with in terms of the magnitude of denials that we're seeing as compared to other disability insurance companies, because we probably see more disability insurance denial claims than any other law firm that's out there. But in these videos, we like to talk about why Guardian denied our client's claim, what we were able to do to get the benefits reinstated, and then some tips for claimants so that if they are to have a problem with Guardian, they know that they have options and things that they can do to prevent a denial from happening. So give us the background of your claim.
So our client came to us after, she came to us after being denied benefits. She was actually on claim for 3 years. And let me give a little bit of background into her claim. She worked as a legal secretary for a law firm in Georgia, worked there for over 5 years. Hard worker, good worker, had some heart issues. Went for an outpatient ablation procedure, pretty typical procedure. Normally, things don't go wrong, especially outpatient procedures. Unfortunately for her, something went wrong. During the procedure, she ended up having a stroke. I'm not sure if it was malpractice, who knows, but whatever happened, that outpatient procedure ended up leaving her in the hospital for 30 days, 2 weeks in the ICU, going into rehab to learn how to walk again, learn how to do everything again, feed herself again, basically 24-hour care after that, family members taking care of her. After that time, using a walker, still uses a walker to this day, mind you. Luckily for her, her law firm provided her with disability insurance coverage, and her policy was with Guardian, and she applied for benefits and initially was approved for benefits. And actually, they paid her for 3 years. Her policy has a 3-year own occupation provision. Now, most of these policies, as you well know, most of our people that watch our videos probably know by now that most of these policies, these group policies, have these change in definitions of disability, where they'll pay you benefits for the initial, typically it's 2 years, for initial 2-year period if you prove to them that you're unable to perform the duties of your own occupation. And then after that point, it gets a little bit more difficult to qualify for benefits. Then you have to prove that you can't do any gainful occupation or any occupation. So in this situation, her policy had a 3-year change in definition of disability. So they paid her for the initial 3 years. And at the 3-year mark, they denied her claim saying, hey, listen, there's a change in definition of disability. We think you're stable. We think your medical records show you're stable. You can go back to work. So she reached out to us, and I looked at the case, talked to her. She told me everything that she's going through on a daily basis. And I was like, what is going on here? How can this lady possibly be stable? What she described to me, what she goes through on a daily basis, I was like, I'm sorry for being crude, but what are these idiots doing? Some of these denials that we see are egregious, and this one was egregious, and we had to win this case. And you called it a resolved case. I guess it's resolved in the sense that we won the case. She's on claim receiving benefits, but it's still ongoing because we're still proving the case to the insurance company to make sure that Guardian does not deny her again.
What did Guardian rely upon to deny benefits?
Not in-house, but they went out and got 2 consultant reviews. And these consultants did they basically are just biased consultants that they look at the medical records and they only see, I guess, the flowers. They ignore all the ugly parts of the medical records that show where this lady's still suffering. This lady has, vision issues. The residual impacts of a stroke. Yes, she got stable, but stable for her ain't the stable that she was before she had the stroke. And mind you, she's not even age 50 yet. Maybe she just turned 50 this month, actually. So she's a young person. And yeah, she's stable, but stable that she's not getting better in that sense. So they highlight the word stable, but they're overlooking so much that the fact that she uses a walker, she has vision issues, suffers from pain, left-sided weakness, hand issues. And the other thing they relied upon, they used these consultants' reports, then they used their in-house vocational analysis and this vocational analysis says, oh, we think you can do sedentary work. Here's 2 sedentary jobs we think you can do. one of them being a secretary. So why did they just pay her for 3 years saying, oh, we believe you can't do a job as secretary, so we'll pay you for 3 years of disability benefits. But now 3 years later, there's a change of definition of disability. We think you can do the job of a secretary or a receptionist. Mind you, she has hand issues where she can't type. How can she do a job as a secretary if she can't type?
So what did Guardian do? Ignore the medical records?
Ignore the medical records. So what did we do, right?
But how did they go out and hire 2 clowns to make findings to say this person was better? With all, I mean, you've rattled off a list higher than almost any client we've ever had, and we've had thousands of clients.
Well, I can answer that. There's clowns out there. There's a big circus out there, and they can go to hire clowns that will write whatever they want them to write, unfortunately. And we see the clowns on a regular basis. So we know their names, and it makes it easier for us to respond to their reports. You know, and it's a sad thing that they do. I'm sure there's good consultants out there that do a good job, and we see their reports, and people come to us when they've been denied, and I say to them, I'll do my best job, but this guy did a good job.
Right.
Your medical records are what they are, and you're claiming disability, and I'll do my best, but here's what we are. Here's what we're having here, But in this situation, there was poor consultant reviews that led Guardian to deny this claim, and I don't know who was leading who here, whether Guardian just wanted to deny this claim or whether the consultants just put it in their head. I don't know.
All right, so let's fast forward to what did you do in order to get benefits reversed?
So obviously, a lady with a walker with residual impacts of a stroke, vision issues, left-sided weakness, hand issues. Easy. First thing I had to do is obviously get updated medical records, get the claim file from the insurance company. But I sent her to a functional capacity evaluation. Functional capacity evaluation done by an independent physical therapist that we went out and found says there's no way this lady's unemployable. She can't do sedentary work. She has, for those reasons, she can't type. She can't sit all day. She can't type. She can't lift. She uses a walker. They stress the fact that she uses a walker. I took that, sent it to her doctor. Her doctor did an updated attending physician statement, said, I agree with the results of the FCE. And I've been saying this before, even the results of the FCE, this lady cannot do any occupation right now for all these reasons, and list the same reasons: fatigue, left-sided weakness, yada, 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 everything. The next thing I did is I hired our own vocational expert, and he was up there. I gave him all the results of their vocational analysis, their independent consultants' reports, our results of the functional capacity evaluation, some of the medical records, and our doctor's attending physician statement, and basically said, there's no way this lady can do the job of a secretary or the job of a receptionist. This is ridiculous, Does not have the ability to type, let alone sit all day. So I put this all together in an appeal, and the appeal wrote itself, because we did so much background into this case. And this is not a big case, mind you, because the lady, I left this part out. She's approved for Social Security disability as well. So Social Security Administration found that she's disabled from any gainful occupation. Okay, so we have another entity finding her disabled, so Guardian was able to utilize that award to pay her less. So this lady's benefit is less than $500 per month.
Wow.
But I took on this case because it was a BS denial, and we can't let that happen, right? So we didn't let that happen. Now we have her back on claim now. But again, the appeal almost wrote itself because we did so much background into this case to make sure that Guardian had no alternative but to reinstate this claim.
Well, it sounds like you did an amazing job. And when you say the appeal wrote itself, it ended up in your mind feeling that way because you had obtained so much additional evidence that we really like to win these cases on the facts. And you were able to get additional objective evidence, and whether you called subjective evidence, letters from her doctors, letters from people that she worked with in the past, letters from family members, as well as medical. You said you did a functional capacity exam as well. So you had tons and tons of additional medical evidence that it was basically like, yeah, we can put in a lot of argument, and we do. But because you've done so many of them, you felt like this one was so supportive that you didn't have to do a lot more in terms of writing this extensive, crazy letter, because sometimes you can argue to say, is Guardian even going to read the letter we submit, or are they just looking for the evidence? And it's a mix of both, but there's strategic things that we're putting into the appeal because we obviously want to win the appeal, but as lawyers who have handled thousands and thousands of these cases and litigated them, which is the next step after the appeals loss, we're thinking about what is the judge going to read? So while we are writing for Guardian, we're really writing for the court. because we're writing for the judge to say, Judge, here's our appeal. We gave them everything on a silver platter. It was overwhelmingly obvious that our client is not able to do the duties of her occupation or any gainful occupation, which was the standard at the time that they denied her. And there's no reasonable basis whatsoever. They cannot possibly find any reasonable doctor who could disagree. And luckily, Guardian did the right thing in this case and reversed. But had they not, then the judge would have had everything in the way in which you laid it out. So super important how you write the appeal letter. And even more important is the evidence that we obtain.
When I say it wrote itself, believe me, I put everything in there.
Yeah.
You know what I mean? It wrote itself because it made it easy for me to list A, B, C, D, E, and F where they messed up and where I could point to where they messed up and where I could remedy their mess ups and say, this is what you guys should have looked at. Here's what you should look at now. And here's where the truth of the matter lies. She's disabled.
Well, you did a great job. And I know she has you on the claim to continue to protect her benefits because Guardian could cut her off again. And now I know you're advising her and reviewing her medical records and working on the claimant statements and the attending physician statements, because Guardian still evaluates every month or every 3 months or every 6 months. It just depends what they feel like doing at the time. You would think with this one being a benefit under $500 a month that they wouldn't bother with this person, but look, they did. So nobody's safe, whether you have $500 or we have benefits that are $100,000 a month. They treat you the same, and that's another good example of what happened in this case. So if you're someone out there with a Guardian claim, feel free to reach out to Alex, myself, any of our lawyers. No matter where you live in the country, we're available to assist you, and we'll always provide you with an initial free phone consultation.